Non, non, c'est... Hello to everyone. I hope you had a good study-free week, that you managed to tank up some more energy till the end of this semester. You have seen that for today you have prepared a case study, which we will be discussing very shortly. I would just like to give you a few introductory words about hate speech also under the European Convention of Human Rights, as this is relevant for the case study. We discussed before the study-free week hate speech in the United States and also in Canada. We saw quite different approaches there. So what about the European Convention on Human Rights? You may remember that I also mentioned that the European Convention has been adopted after World War II, 1950, and has provisions which reflect also the idea of a militant democracy. Remember the idea of a militant democracy, the idea being a democracy which, in a way, is able to defend itself against its enemies. And the court has, the European Convention has a provision, Article 17, which is sometimes called the guillotine clause. That's why you have a guillotine on the slide, not because I'm particularly macabre or so. So why is it called the guillotine clause? Because it is said to kill an application. It is, when you read Article 17, it's the prohibition of abuse of rights, the idea being that in certain circumstances, invoking a right can be an abuse of rights. If the court in its case law basically uses Article 17 in two ways. One way, that's when it kills the application, is to say, well, basically the application is inadmissible. We will not examine the application. So the court will not use Article 10, freedom of expression, and go through the limitation clause, legality, legitimate aim, proportionality. It will simply say here, the invocation of Article 17 goes against the fundamental values underlying the convention. Basically, it's an abuse of rights. We will not go any further. So it is quite, I would say, a strong medicine, because you will not go into proportionality, etc. Then sometimes the court uses Article 17 in a more indirect way when assessing the proportionality of an interference under Article 10, paragraph 2. To give you some hints at when the court uses Article 17 in a direct way, so it kills the application, it's mainly if it's very extreme statements of racist, xenophobic, Islamophobic, homophobic speech. And that can also include speech by politicians. So the court, for example, relied on Article 17 in cases, the first few cases are all about Holocaust denial as well, Garodi, Pastors versus Germany, Williamson versus Germany, and other cases, extreme form of hate speech. Pavel Ivanov was a case where someone basically accused the Jews of anything bad that can happen to you, the very typical anti-Semitic tropes of conspiracy, etc. Then I will just mention maybe one of the latest cases, Lenis versus Greece. It's the first time the court applied Article 17 in a case about homophobic speech. I saw that scholars have been divided. Did the court apply Article 17 too easily or not? I will just summarize the facts to you, and I don't know what you'll think about it. So it was someone who had in Greece a high position, high cleric in the Orthodox Church, And in Greece, they were debating also same-sex marriage. And he published a blog where he basically treated homosexuality as social felony, as sin. He called homosexuals the scum of society, defective, mentally ill, and invited people to spit on them. There's quite a lot of counter-speech criticism, which made him say later, let's get things clear, love the sinner, but deal with the sin. And he claimed that saying basically you should spit on homosexuals, that was a metaphor to say we should despise them. So here the court felt, well, this is really, beyond it's a dehumanization, saying, calling someone the scum of the earth. The court also interpreted spitting on can be also a call to violence. It took into account that this person has some impact. It's a high position in the church, and also that when you spread something via the internet, that has also more impact, and that homosexuality is a protected ground. We have to deal with a vulnerable group. So I don't know what your opinion would be on this case, but I find it's quite a clear hate speech case. So the court really then can apply Article 17. If the court finds, well, maybe the statements are not as extreme, the court will examine the statements under Article 10, paragraph 2. So it will do mainly, the outcome of the case will vary based on proportionality. So you will find cases where the court will find in favor of the target group. These are a few examples I have noted on the slide. For example, Ferre versus Belgium was a politician who had held a lot of xenophobic statements, statements against migrants. And two other cases, Weideland versus Sweden, it's again homophobic speech, someone who left leaflets in the locker of school children saying that, making a link between HIV and homosexuality and pedophilia. But you can see here the approach is different. You will do a proportionality assessment. The court does not apply Article 17. And then you will have cases where the court basically finds, well, here the balance tips in favor of freedom of expression. For different reasons, I have on the slides, I may not go with you through all the slides, but I have summarized a few of these cases. Either because the court finds, like in Lehide and Isoni versus France, it's more a question of a historical debate also. So the case study we are dealing with today is within this framework, so we'll have to be debating, well, are we under Article 17, yes or no? If not, well, it's 10 paragraph 2, and I'm quite curious to listen to you, to see what your assessment is. I know you have roles to play. You may be attributed to, you have to defend maybe a role which you may not naturally agree with, but this will also be, if you work as lawyers, this is what is coming your way. So it's a good exercise sometimes to take position. Maybe just to get an idea, who are Perinček's lawyers? Okay, not that many. The government? Okay. I was wondering whether, do you mind moving seats? Can you cope with that? Otherwise we could say that maybe we regroup Perinček's lawyer rather on this side and Swiss government on this side. So, and I said Perinček here, right? Perinček, Swiss government. And I suggest I give you maybe 15 minutes that you can exchange a bit with the people sitting around you and see what ideas you could find. So I repeat, the Swiss government is here, parent check on the other side. So, dear teams, I hope you managed to get collect a bit arguments. So the idea is not, I'm not expecting that you now have that you do a big statement or something, but the idea is that we will be going back and forth and we'll try to have a debate and we'll be collecting arguments. So really don't feel it's a formal moot court exercise. It's really to foster a debate on a case which is quite complicated, where people can have legitimately also different opinions. So the case was brought by Mr. Perinček against Switzerland. So I think we will first give the floor to Mr. Perinček's lawyers, as they are convinced that his convention rights have been infringed. Are you sorry, Perinček here? Sorry, confusing everyone here. So who is? It could also be several people taking the floor. Who wants to start with some arguments, some claims you are making?
I can start. So I think one of the first things is that we want to be very, very clear that this should be examined under Article 10, subsection 2. This is not a case of Article 17. When you examine his actual statements, he was not calling to incite violence against Armenians. He's discussing a historical debate that was an open debate in Switzerland until 2 years before his statements. In 2003, in Switzerland, they were still deciding whether or not to classify this as a genocide. So the fact that he would be engaging in this debate is something that should be examined under his rights to freedom of expression, which then are balanced against the right to dignity under Article 8 of the Armenian descendants. But so there should be a very clear balancing exercise, and so that would be the place that we would start.
Okay, I think we have a clear starting statement. Who wants to add something? Otherwise, we can.
To what she said, she simply meant like to criminalize the speech of what he had said. It basically strikes the core of what Article 10 protects, which is a marketplace of ideas.
So we have a lawyer who's very well versed in comparative law, importing a little bit of American case law. That's totally legitimate. An argument. I can see the.
I respectfully disagree with Madame. And I think we should basically go back in the history, because it was a conference, and I would like to quote paragraph number 5. It was at the Hilton Hall to commemorate the Treaty of Lausanne, which, and I would like to talk about it, and I think it's important because the Treaty of Lausanne replaced Treaty of Serbs of 1920. Treaty of Serbs holds a particular influence in this case because provided accountability and responsibility of the high responsibles of the Armenian genocide. So basically the context on here, it's really important because Monsieur Perinček choose this space to create an ambience of a racist ambience, and choose very, very well the space where he expressed his speech.
Okay, so in your view, are you pleading in favor of applying Article 17 or Article?
I do agree with 10, but yeah, I mean, this is not the main argument. Just for starting and opening the debate, I think we should look this historical context, because it's a commemoration of the 90 years of Lausanne Treaty, which replaced SEPA. So I think it's important to see that before going to the main arguments of the legal absolutely.
Okay. Any other arguments, maybe on Article 17? I think you did well to start with that, because I think that really... Or Switzerland can live with a yes?
We are also talking, you were talking about freedom of expression, and I am going to refer to the Article 10 in the BIS 2, where it says that everybody has freedom of expression, but they have to basically take responsibility of the words they are using. And so in relation with Article 17, we have to remember that we are talking about the rights of a group of people that are being denied right now, and we are provoking tensions between between different communities. In this case, the Swiss Armenian community and the Turkish Swiss community. So we are forgetting the values of tolerance and dignity.
So you say it's the values of dignity and tolerance. We may have to talk about, and also what are the values at stake here. I will write down dignity, tolerance. I had the impression that the Swiss government was not adamant that Article 17 absolutely had to apply, but you clearly say under Article 10, paragraph 2, you have quite a few arguments to be made, or maybe I can see.
Maybe one short point is that now that, like in the recent years, in different court decisions, the Armenian genocide has been established, and therefore the distinction between the Holocaust denial or the Armenian genocide denial is more difficult than it was 2005, 15, my bad. And therefore, I think Article 17 should or could still apply.
So you are saying in a way that would be an unfair distinction between the Holocaust on the one hand, where the court does apply Article 17 quite regularly, and the Armenian genocide.
Deny basically human dignity of the victims.
Let's maybe give the floor. What does the pairing check team think here?
I just think that the distinction between the Armenian genocide and the Holocaust is not unequal per se, because that's why context matters, because the Armenian genocide didn't happen within the European territory, in contrary to the Holocaust that happened in Germany. So the human dignity of the German descendants is more easily touched than the dignity of the Armenians, because there is a sufficient link between the Germans and like the territory where the Holocaust happened, in contrary to the Armenian genocide. So there is not a sufficient link between the Armenians which who are found on the Swiss soil and the Turkish, the Turkey, Armenia, and stuff like that. So it's just context based. It's not. That's why context matters.
So we hear context matters, and countries like Germany, they actually were very much concerned by the Holocaust, but they have nothing to do with the Armenian genocide. We may have to talk also about Switzerland, but I can see several hands up. Maybe you start here. So I can hear here a more universalist position, and also the margin of appreciation, if you say Switzerland can deal with it with the way it wants. There were several people having their hands up.
Additionally, the states have in international law obligation to ensure the observance of human rights.
And this duty to observe human rights for you entails the duty that you have to criminalize genocide denial. Is that what you're saying? Because you say, yes, there's a universal duty in a way of you have to respect human rights. So I'm just trying to make the link between genocide denial and the observance of human rights. Maybe that's an issue we'll have to return to and deep dive, but I heard your argument about the link to human rights. Other, yes.
Even if we want to be context specific, both genocides happened over multiple countries or modern countries. The Holocaust happened in not only Germany but all over Europe. Happened in Hungary through Hungarian soldiers who were not only Germans but over multiple nationalities. And the similar happened with the Armenian genocide that was happening in modern Syria, in modern Greece, modern Turkey, so also in multinational states. So obviously more states need to be talking about that.
So hard to insulate in a way who was concerned.
Also to this argument, if the Swiss government would be possible to write these laws about the genocide on the Jewish people or the Holocaust in general, which didn't happen on Swiss soil, why should the Swiss government not be able to have laws relating to the genocide on the Armenian people, which didn't happen on Swiss soil?
So we have here, I think it's time to give the floor to the Perinček camp. We can return now, we have the time.
So I'm going to have to agree, obviously, with my colleague here. Context is important, I'll tell you why. Like you guys, like you have said earlier, it's not until recently that the Armenian genocide was recognized. And I think it's important to acknowledge that that evolution was able to happen because these conversations were allowed to happen. Basically, the Armenian genocide for a long time was debated if it was like a bloody war or a genocide because of the historical facts and the facts that that governments would not agree upon, like historical facts. And I think what's important to remember here is that, like my colleague said, Switzerland has the right to make the laws they want, but it's also a country that is neutral enough to allow these kind of discussions to have place. This person here, like my colleague said earlier, did not make any insulting or bloody or a call to violence kind of remarks. He was trying to bring forward historical arguments to yes, say that this was not a genocide, this was another type of crime. The thing is that if this had happened in another country where Armenians are dominant, where they're the majority of people, I think we would have had different discussion. But Switzerland is the place where you can maybe have these types of open discussions to eventually come to a different conclusion. So here, the idea is that sometimes to be able to evolve our ideas around a subject, a matter, a crime, war, genocide, we must be able to have some safe space to be able to discuss it openly. Like you said, words do matter. But our client here was not inciting violence. He was trying to bring forward historical facts. He was trying to bring his opinion on the table. And the fact that he would be censored for it also causes a problem to say, okay, but if we start censoring everything about a specific conflict, then maybe this market of idea might be put aside and maybe we would not be able to do the same for another event that needs to be talked about and explained within society. So I think that to censor something without even giving someone the chance to express it in an objective or in a polite way could be dangerous.
Okay, we've heard what the position. But I'll give you the floor as well. I don't know which one. And if he had wanted to shock and disturb, would that mean it would not be protected by freedom of expression?
In this context, it's clearly shows under the Swiss law, there are not protection for freedom of speech, but at the same time you have restriction for that to protect or offend that.
Because you know, as European Court, I would like just to remind you that freedom of expression protects statements which offend, shock, and disturb, but there are some limits.
Because Switzerland is not monolism country, because it was a part of the European Union, but we are not right now. That's why we are taking that neutral path that you can.
So just to, maybe Switzerland is not a member of the European Union, but we have ratified the European Convention, which this is why this court is competent. So maybe we give it space to answer on this side. And I was also a bit intrigued. I was wondering, does it make a difference whether you say the events have not happened, or whether it's just about saying it was not a genocide, it was a war but not a genocide? Is that something important or not, in a way? But I'll let you answer if you have other things you'd like to say.
Yeah, I wanted to go back to a different point. You guys said that he was only talking about historical facts, but in one of the speeches he also referred to the Armenians as instruments, which denies them of their dignity. So, yeah, what do you say to that?
So dehumanization, they are just instruments without, let's stay a little bit with whoever.
And I think they also shift the blame during the speech. So he puts the Armenians as the aggressors and killers of Turkish and Muslims. So this is not just his opinion, but also the creation of a new fact that in his mind makes sense, but that can create repercussions towards the community of the Armenians here in Switzerland or around the world, because it is a digital age, so that speech will for sure be around.
So this is an argument against saying it matters so much where this speech happened. But let's go maybe back to the Perinček camp.
So I would like to respond to my esteemed counselors by agreeing that context matters and agreeing that the way in which his statements are going to be received is part of a balancing act that should be held as you are weighing whether or not he has the right to his freedom of expression. Unfortunately, the Swiss courts did not engage in such a balancing act when they said that he, in just the simple act of denying that this could be classified as a genocide, without denying the historical events, by saying they were instruments of the imperialist powers, most of his vehemence in his arguments was actually not directed against the Armenian people themselves, but against the circumstances that allowed for these tragic events to occur. He was disagreeing with the classification of those events as a genocide without actually somehow calling for any form of hatred against the Armenians themselves or their descendants. We're talking about events that happened over 100 years ago. By the time of this court case, and that it is something where his freedom of expression should be balanced in this case. Instead, the Swiss courts criminalized the act of genocide denial without balancing his right to freedom of expression. And that is something that Switzerland has agreed to honor by signing the convention. So this is, if what is necessary in a just and democratic society is the thing that we should be balancing, and that was not done in the Swiss conviction process.
So I heard in your statement that it happened a long time ago, so we'll see whether, if is that relevant according to the Swiss government, and that it's more that he actually shifts the blame, and also what did he actually say, what was the meaning. So I understand you saying he did not contest the facts, he was the classification, it's not a genocide, and secondly, wait, so what was the...
One more thing, because I forgot one of
Yeah, and he blames, it's not a blame on the Armenians, he blames the imperialist powers.
And we can see this also because he's not being convicted of hate speech. He's not being convicted of targeting them as victims. He's only being convicted under this criminal code for the genocide denial.
What does the Swiss government think of this? Maybe take a few. Do you agree? Maybe you have a different reading of the statements. I don't know. It's just about, yes.
We're not talking just about the denial, but and I would like to quote 169 of the paragraph, which it required in addition that these acts be carried out of the ground of race, ethnic origin, or religion. So basically, we have the prior conduct that he was part of the Talat Pasha, and according with that, we have the obligation.
Could you maybe explain, this court is unfortunately very bad at history, so who is Talat Pasha?
Who is that group?
Did someone?
It was a racist group, but I have no clue.
A racist group, okay. Any other? Because it's true that Perinček was part of a committee which wanted to rehabilitate, I think, Talat Pasha. So. Maybe what we can do, let's have a break so the teams can look at. And it's a good question, does that play a role? So we'll resume 15:15, if that's okay. S'il y a quelqu'un qui essaie d'envoyer une tarte sur la
Non, non, il n'y a pas de souci.
Okay, I hope that the two lawyers' teams had time to relax and to find out more about Talat Pasha. So is that relevant, that in your opinion, that the link to Talat Pasha and so on? Ah, we have the Aytala, the historic expert. We have.
So Switzerland argues that Talat Pasha was, during World War I, the architect of the Armenian genocide. And so someone today who's pledges support and then denies pledges support to Talat Pasha and then denies the Armenian genocide is equivalent to pledging support to Nazi officials like Adolf Hitler and then denying the Holocaust. We think that that's like a factual equivalence that the court refused to consider in this case.
What does the Perinček team think about? Are we back to the comparison of the Holocaust versus the Armenian genocide? You're saying, in a way, it's as if we allowed someone to praise Himmler. Say.
So unlike the Holocaust, which was recognized by historical and judicial facts in international tribunals, the 1915 Armenian massacre has not been recognized by any international courts. Therefore, there is no binding or legal factual determination that would justify what Switzerland was saying about it.
Is there an international court which clearly said that the Holocaust was a genocide?
Holocaust, yes, but genocide, no.
That the Holocaust took place and so on, but whether there was an international, maybe you have to fill in the court's knowledge on that, if there are other international tribunals who authoritatively said, well, the Holocaust was a genocide. Maybe we can also shift, yes?
The 1965 International Convention on the Elimination of All Forms of Racial Discrimination, it stated that the Jewish Holocaust well, this is like the base case that they are using, and they are saying that the term any genocide should be used rather than only genocide in the convention.
Which provision are you referring to of ICERD?
The National Council 7, yeah, the International Convention on the Elimination of All Forms of Racial
ICERD.
Discrimination, the 1965.
But are you referring to a specific provision in the convention? Because this is a convention which basically applies generally to racial discrimination as an Article 4, by the way. And Article 4 does talk about genocide or Holocaust denial.
It used the term a genocide by way of reference to any genocide that may unfortunately take place.
So you're saying ICERD is broader, it does not limit it to the Holocaust, is that the argument?
Yeah,
Maybe one question we should delve at, so I've heard quite a bit now as a court on the Holocaust, the Armenian genocide. What actually is the legitimate aim of the interference? What is Switzerland trying to do by saying, it's a criminal offense, what Perinček said? Maybe we start off with Switzerland here.
Sure. So Switzerland believes that the statements made, specifically the ones that emphasize Armenian killings and then also emphasize the imperialists are part of a typical conspiracy theory used by Armenian genocide deniers. And so even though in the statement he doesn't say specifically what Turkey did was justified, he's taking the steps in a typical conspiratorial pattern to make those implications. And Switzerland believes that it has the right to protect its citizens, especially citizens burdened with this history of Armenian descent, to protect them from conspiratorial thinking that denies the suffering they went through and denies their dignity.
So you say we have to recognize the suffering of the Armenian communities. So a denial is basically, in a way, it creates a. If you deny it, it's reinforcing a trauma. Is that what you say?
And like going a little bit deeper on that, like basically by denying it, you're also dehumanizing the entire group. And it's mentioned by the court that it could also have an impact on the group's sense of identity itself. And by denying also the act, you could also have an effect on the private life of any person of Armenian descent, which would be an entire attack on human dignity as well.
So we have dignity, sense of identity. It's a lot of Perinček team. Do you agree with that? I can see someone.
No, I disagree, because there is no evidence that at that time when the applicant made his statements, the atmosphere in Switzerland was tense or could result in friction between Turkish and Armenian people. On top of that, the court had found that we cannot, I'm sorry, let me just find where we can see. Oh yes, so when they convicted the applicant, the Swiss courts did not refer to the Turkish context, nor did they in their observations. So they cannot justify the interference by reference of these articles, because there wasn't any domestic political context that was implicated at that time. So no.
So we're back to the context. It happened in Switzerland, no big anti. What about the identity and trauma? Is that for you a relevant argument or not? Saying if I'm Armenian and I'm being told, this was not a genocide, what you lived, you were kind of the instruments of some imperialist powers, etc. The good argument, not a, yeah.
Yeah, but I think it's still very important to stress that he didn't deny the event that happened. He was talking about qualification of events, like he was provoking debates. It was really like political speech. It was speech of public interest. He didn't say like Armenians, you didn't suffer. He just said, is this really a genocide? Like, isn't this influenced by other countries? And that's why he called them instruments. He didn't say you're instruments because you didn't feel any suffering. It didn't happen. No, he actually acknowledged it happens. But he's just talking about the legal qualification, which is a thing that, as we have already said, Switzerland wasn't sure of, like even a few years ago before he said this. So it's really important to stress that, I think.
So you're saying it is speech on a matter of public interest, a core speech which the court has to protect strongly, very little scope for restrictions. Yes.
But still very much cast the Armenians in a negative light, because it is very different if you as a community are perceived as a victim of a genocide, or if you are perceived as an instrument that imperialists used to commit violence.
So you say there's still some impact how the Armenians
are cast in a negative light, which would nevertheless hurt their dignity and sense of identity.
So we have one hand here, and then we go back. We'll have them.
Switzerland also wants to push back on the notion that the recognition of the Armenian genocide as a genocide only occurred in 2003. Switzerland acknowledges that only a limited number of countries officially designate events as a genocide, and that has more to do with geopolitical reasons than actual determinations of what happened.
What are those geopolitical reasons? Why do you think there is so much debate about it? Oh, in a way, why did countries not earlier say?
For one, especially countries in the West want to maintain close ties with Turkey, which has had a position of downplaying the events from a genocide to something below a genocide for nearly a century. But if we take a look at the work of historians, legal scholars, the recognition of what happened in Armenia as a genocide predates 2003 by decades.
Okay, so you're saying in a way it's Turkey's political stance which influenced, which is important here. Turkey just denies what happens, but there is a very strong consensus apart from that. Maybe the Perinček camp?
I don't know, there is still no international consensus on how to deal with this issue. So it's also really important factor because some countries they criminalize the genocide denial, other countries they don't. So it's also really relevant factor. And I also would like to add that my colleague said that this statement hurts Armenian people. I think this is inevitable. This is like the core of political speech. You will hurt people. You will shock people. And as we already said, like in our Handyside judgments, this is the core of political speech, and that's why it needs protection. Because speech that hurts people, yeah, it's most likely the speech that will get censored.
So in a way, the question is, have we got just speech which is shocking, okay? Or is it speech which does more than shock? And maybe you mentioned dignity. In what way does it impact dignity? Or I don't know who would like. I saw a hand up, you want this?
People have right to express their ideas because Switzerland has identified as
and you accept other people's idea, and you have a right to deny that, but still that person, the other party has right to express their feeling or whatever, not the opinion, actually idea about the past or the future.
I'm just as a court grappling with this time element. What about the Holocaust? When would you say also, well, now it's been how long? About 70 years? So in 25 years, it should be treated like the Armenian genocide, so we could deny it, it would be too far back. What is the time criteria? Is that a relevant or not a relevant factor?
I don't believe it is, because we have to remember that it's about proximity and degree. There are two notions that we have to remember. And on top of that, we have to see, can speech actually be limited if it, we saw that speech can be limited if it hinders to war. This isn't what he was saying at all. So at the end, just because something is shocking doesn't mean that we can censor it, or that he can be punished under free speech for that.
I just understood that you were making a difference between, are you saying maybe we should have the court should have a different position when it comes to Holocaust denial? Also say, well, there can be different opinions. Okay, Germany, as opposed to Turkey, does not deny that these events happened, but if people are defending different points of view, that should be allowed too. I'm asking the question as a court, just should these two events be treated the same way? Yes or no? And then we can decide which way, in a way. Either we allow any denial or similar statements, or the opposite, we say in both cases. So I can see.
I think one of the things that's really important in this decision is, can we look at, does the Swiss law under which he has been convicted also take into account the values of the convention, and is it in line with Article 10? And so one of the things from our side is that the Swiss courts never took into account his right to freedom of expression in this conviction. And so that's why we're asking the court, the European court, to actually do this active balancing. If Switzerland had done a true balancing act and decided that they wanted to convict him of hate speech, or that they were actually looking at his right to freedom of expression in a balancing act between that and then the right to dignity of the Armenian descendants who are members of the Swiss community, maybe we could give a larger margin of appreciation to the Swiss judgment. But because the Swiss courts never included his freedom of expression, then it means that we can't, we need the European court to actually take the full balancing act.
So you were in a way taking a procedural approach, like in the von Hanover cases, etc. So Switzerland, you didn't balance. What do you say about that?
I think we're forgetting about the way that he was doing the speech, which was a political way. He was talking from a political point of perspective, and he was talking to a crowd. So even though there wasn't this conflict at the moment between Turkish and Armenians, that could have been a point of start of a further conflict in Switzerland. So I think that the argument that there wasn't this context of conflict at the moment in Switzerland is not viable. And I believe that we observe the freedom of speech, the Article 10, and we understand as well that there are serious ways of which freedom of expression goes beyond its limits. So the way that we see that speech and his position and the context of his life, his background, his perspectives, is that the intention was not solely to create this discussion about if the Turkish and Armenians were instruments of the imperialists, but also to create this idea that the Turkish people are not as responsible as we would like to think of the killing of the Armenians. So So the denial of the genocide is very clear in his speech.
So for you saying, okay, it's clear denial and basically Turkey doesn't take its responsibility, which it's a minimization of
You talk about intention, but I think intention is something really hard to measure. What's more important is the effects it had. And if we look at the case here, present case, nothing happened. Kajusek, he made those statements, and if you look at what really happens, nothing happens. There weren't any moral conflicts, there weren't any rallies. It didn't produce any effect.
So no disorder, no, there was no riots and so on. Okay. Maybe, and then we go back to the government. Okay.
To add to the argument of my colleague, just because it could happen, like because the government took a preventive approach, and we understand that, but just because it could happen, it doesn't mean that it was necessary. That's why we're arguing that it was not necessary and proportionate in a democratic society. We're not questioning the margin of appreciation or the way the law is created, just the way it was applied in this case. And so to finish it with a sentence, correlation is not causation. You didn't give us specific proof that the speech could result to violence. So again, correlation is not causation.
So you're saying you have to do a stricter assessment of, you cannot just say hypothetical danger would be enough, I think.
Yeah, I would just like to reply to your statement. You say that intent is hard to measure, and then that nothing happened. But I would like to know, how do you measure how a person feels about the speech, how the Armenians felt when they heard this, and how do you recognize if someone felt like it was against their dignity? Because as Swiss government, we see this is a problem. We need to protect the Armenians who feel threatened or who feel like this is against their human dignity. And this is something that is way harder to measure than any uprisings or something like this. And there's not a real limit where we can say, okay, now they feel threatened, so we need to protect them before they start with
So you're making, it's actually a different claim. It's not about disorder and so on, riots, but you're saying it's the impact on the victims, which you say is not that easy. How do they know what it means for the Armenians, etc.? I suggest, because we have, I think it's a very interesting discussion, maybe one closing statement or one last statement. I don't take it as, oh, I have to make a big statement. I think, should we first give first the Swiss government, because before it will be this.
And we have 2 minutes to regroup.
If you want, okay. And you too, a last statement. think it is time for a last statement. It hasn't got to be a big statement on each side. Is the government ready for a last? Okay. So where's the spokesperson of the Swiss government? Okay, we're listening to the Swiss government.
Thank you. We would like to say that the denial of a genocide is not a short-term result, but a long-term result, and because it is so hard to find the specific time where a genocide has been too long ago or too far away to have laws regulating what you say about this genocide, we would like to take into consideration the impact the words have, also the long-term impact, and in this case, the Switzerland-Armenian Association brought this claim, which shows that the speech clearly had an impact also in Switzerland. And here it is really important to consider the human impact on how people feel that consider themselves Armenian or Armenian descent. And therefore, we think it's really important to prevent history from repeating itself by preventing any hatred between different people. And therefore, it is so important to prevent this violent interaction between people, which can only be prevented by preventing this speech from making people feel impacted or like someone denies them of their dignity. And we would like to close our statement with the sentence, those who deny history repeat it. Therefore, we are strongly in favor of laws regulating what you can say about genocide, and if you can deny it, we deny.
You did find a real closing statement. Okay, yeah, good. Those who deny history repeat it. So, what has the Check team got to say about this?
We would like to very much agree with the Swiss government's claim that people could be impacted by speech. That's in fact the point of speech. But in fact, in a free and democratic society, having speech that could offend people is one of the goals of what we are trying to create here. If we want to be able to actually prevent future conflicts, one of the ways to do that is to have a free and open debate. And so having a criminal code that denies the right to freedom of expression to someone just for their categorization of a historical event without doing the proper balancing, and where the impact has to be understood. It's not that there is an expiration date on genocide. That's not what we're arguing. It's that there were no survivors of this genocide who were here being affected by his speech. As the generations slowly come away, the offense to their dignity is watered down through time. Time heals all wounds. So this idea of time is not just for, that somehow there is some measure that we can use here, but in the actual impact, yes, people were offended by this speech. They are allowed to be offended. And what we are trying to ask for the European Court's decision is that we want to have these debates so that in a free and democratic society, we can come to some version of a consensus and or disagree with each other and continue living side by side. That's the whole point. And so saying that someone who disagrees with the Swiss majority viewpoint that there was a genocide in Armenia, and therefore criminalizing him, that is unjust.
Thank you very much. So my applause goes to both sides. So first to say, I was really impressed. I think you've done a very, very good job with not that much preparation. I think all the important arguments have been raised. And you have also very well endorsed your role. It's not always an easy role. And, but honestly, I really very much enjoyed listening to you. I think you have done a very good job. So now just maybe a few comments. It's a complex case. It wasn't that. I also talked, I remember, to the Swiss judge at the time who said she spent quite a few sleepless nights thinking, what should we be doing about this case? What is the right answer? And maybe first just a little bit more information about genocide denial. I said it's a hard case. I would like to read to you a quote by William Schabas, who's a very well-known human rights expert, who says on that subject, "My own views on these complex issues have evolved over the years. They may change in the future too. Sometimes I find myself sharing the opinion of the last persuasive person with whom I have spoken, my perspective tilting in one direction or another. I find myself torn between the militant anti-racism of punishing denial and the latent libertarianism that bristles at any attempt to muzzle expression." And I think that's a role the two of you played very well. How to say, one, we are the liberals and let's talk about it, and you saying, come on, I mean, this is basically kind of we're fighting against racism, we're protecting the target group. So I think that at various times in my life I have argued for both extremes of these issues. Now I find myself somewhere in the middle. My preferable compass, international human rights law, seems to have two needles that point in opposite directions. So I think that's just to underscore it is not an easy issue. Now, if we just look at it maybe from, when you look at it from the more of a criminal law perspective, it's also interesting to see different laws. It is mentioned in parent check, countries have different laws. Some have nothing about genocide denial and deal with it as a form of hate speech. Others may have something more specific about the Holocaust. And then when you, under the criminal law perspective, you would distinguish one form is simple denial, where basically you say this did not happen. Okay? Generally, well, there was no genocide. You quite was insisted here that the massacres weren't denied. Okay. Second, and that is, I think, the easier case is, and this is more frequent, qualified denial. And that would basically mean that you say it was made up by the victims. That is, someone mentioned conspiracy theory. It's very present with Holocaust denial to say, actually, the Shoah business, you know, the Jews made it up to extort money from the West, etc. That qualified denial, I think it's easier to link directly to hate speech. If you say, well, this group made it up and they want to make money with it, obviously, you create feelings of animosity against that target group. So and I also once did some research just looking at Switzerland, you know, what kind of cases have we had about denial and so on. And most of the cases tend to be qualified denial. So often, or they come in a context where there's also other hateful statements. Then often it's not, so you will have, as a criminal lawyer, you will think, well, the offense has to be precise enough, but you will also want maybe to make sure there are no easy loopholes. So you think, okay, if we ban qualified denial, people will maybe just use simple denial, but depending on context, it can still be interpreted as you in a way want to cast the blame on the victims. Also, when you will say, well, we ban just denial, what could people do which comes close to denial? You don't say, well, it didn't happen, but you might say you minimize it. So that's also a strategy to say, okay, well, you know, just a few hundred people died in Auschwitz, the rest, well, actually, the ovens and so on, that was normal crematoriums. So that's why often hate speech, genocide denial laws will say also if there is gross minimalization, trivialization, that will also be caught, because you think, well, otherwise people just use this as a loophole. can also, a part of minimizing a genocide can be to minimize intent, to say there was actually no plan ever, to exterminate this group or so. Now we could ask ourselves, and I think if we look at the Perinček case, it could at best be a case of minimization by saying he denies in a way the intent. Okay, he said, well, it was the imperialists and partly he does not talk about Talat Pasha, and there was a plan to exterminate the group. So you could say that's in a way minimization. So one important question will also be, how do we interpret the statements? Is it, on the one hand, more a debate about, almost like in an academic setting where we have a debate, what is a genocide, etc. Is it more a form of incitement to hatred or not? Which also is linked to the question, why do we criminalize genocide denial? And you will find different approaches also in scholarship or in case law. I think the wrong or the less good answer is to say we protect the truth, because it's wrong. Because I think generally just to say we protect the truth, I think the liberals would come back to say, well, we can have debates about those. And I gave you once this example of flat earth. If I'm a flat earther, I might be wrong, but I don't think you would put me to jail for that. It's also interesting, but it's a bit linked to fake news as well. When should you ban fake news? The Facebook, the Meta Oversight Board, for example, says when it's linked to COVID, for example, only if there is an immediate risk that people will act on something which really creates quite an important risk. So I think just to say in general we protect the truth, I don't think that's a good answer. Then one approach is to say, well, it's a form, genocide denial, particularly the qualified form, is a form of hate speech. But that may not, and that was, I think, partly the difficulty here, because your argument was to say, well, he does not, and that's what the European Court said, create an animosity against the Armenians. He says it was the other powers meddling, etc. So it was not so obvious, is this a form of hate speech or not? And the court makes in Perinček this distinction, basically saying, well, in the European context, Holocaust denial almost always is, in a way, a form of hate speech. It's not the case with the Armenian genocide. That has been criticized and debated, particularly taking into account who is the person. And who is the person? Someone, I think Perinček, by the way, also said he would never change his opinion, which raises the question, how can you have a debate with someone who already says, I'm closed, immune to any debate? I said it makes a difference, maybe who the person is. I just want to show you, it was a UN group which was working on hate speech, a UN working group, and they basically established what is called the Rabat Plan, and they basically said we cannot define in abstract what is hate speech. But we suggest factors to take into account. And they look at the context. That was one question here too. So your argument was to say, well, in Switzerland, at the European Court, well, we don't see much of an anti-Armenian sentiment. Your argument would have been, well, nowadays everything travels very fast and, well, it can have impacts elsewhere. Who is the speakers? I think this is what you insisted on by saying, well, he's still a Turkish nationalist who is basically endorses, is a fan of the person who orchestrated the genocide. So Talat Pasha is considered the mastermind, the person who gave the order to exterminate the Armenians. And I think that was also the reasoning the Swiss courts used, basically saying, well, it's like you glorify, they didn't write it that way, but you glorify Himmler, well, so the speaker matters, the intent. We had a discussion, what was the intent? Your argument would have been more, it's still against the Armenians as such. If you look at the situation in Turkey, etc. And you basically said, well, it's not an animosity against the Armenians. He talks about these international aspects, etc. Then what was said? Okay. content, the extent, magnitude of the expression, the impact, etc., and the likelihood and probability of harm occurring, where one argument was to say, well, not much will happen here, no direct impact, and you were trying to argue, well, it does have some it does have some impact. So I'm just drawing your attention to this Rabat plan because I think it's a relatively interesting approach, a contextual approach for assessing hate speech. The European Court actually considered in Perinček it's not hate speech. It followed more this idea, well, maybe not emphasizing much who the person is, but saying, well, we cast the blame on imperialists, etc. Then the question is, are there other reasons to criminalize the genocide denial apart from the fact that it's an indirect form of hate speech? Maybe just quickly, the idea that we criminalize genocide denial as a form of hate speech was taken by the Human Rights Committee in a case, Forisson versus France, where basically the committee felt the French law in the abstract could go too far. You have the slides, you can then have a look at that. But they felt that in the specific case, that denial of genocide, denial of the existence of the Holocaust is a principal vehicle for anti-Semitism. So in a way, if you want to distinguish, the question is it different for the Armenian genocide? But that would be the Human Rights Committee stance here. Genocide denial can be criminalized as a form of hate speech, but maybe not for other reasons. What other reasons could we think of? One reason was mentioned was in a way to say it's also in a way a trauma for the survivors. The court uses also this idea of identity, which has been constructed through, as victims of the genocide. It would be interesting, I'm not a specialist in this, there's also research on transgenerational trauma, that people often keep a trauma which can be handed down in generation to generation. And I read once an article which was quite, I think, super. So it was people, basically women who went to they couldn't go to a hairdresser. They basically had panic attacks. And later it turned out that actually their ancestors had been killed in the Armenian genocide. They had been decapitated. But it was never talked about in the family. And in a way to heal, to get over this trauma, they had to deal with their family history. So I'm just signaling to you this exists, transgenerational trauma, without me having any competence in the area. There's a famous statement by Elie Wiesel saying, in a way, well, if you basically forget, deny it, you in a way kill the victims a second time. So we should really acknowledge what happened. Some people also say that it's typical of it's a typical mode of operation. When people commit a genocide, they will always try and eliminate all traces. So that's also the question, what is specific of one genocide, of the Holocaust? What is common in different genocides? Here I can point to you to a statement by Primo Levi, which basically, I have it here in French, it's 40, he wrote in one book 40 years after Auschwitz. He has a character in there who's an SS officer who basically says, we've won in any case because no one will ever believe, that this happened. It's too horrific that anyone would believe it and will make sure all the traces will be gone. So saying the genocide denial in a way perpetuates this, and you are almost complicit with this genocide, this modus operandi. Then you have also arguments which are more specific. This is what was made by your group saying, well, it's more country-specific. We understand that Germany and countries directly implicated, Switzerland was implicated as well, and so I'm not saying we didn't do the greatest job at that time.